Well, I think we've reached the appointed hour. Welcome, everyone. Thank you. Good morning. It's great to be with you. You know, if you're like me, mention blockchain today, and your thoughts would immediately turn to Bitcoin. And blockchain, of course, is best known for being the technology that underpins Bitcoin. And as we know it today, it was invented by the mysterious Satoshi Nakamoto, whoever that may be or whoever they may be, to serve as the public transaction ledger for Bitcoin. And really today, it supports not only Bitcoin, but other virtual or cryptocurrencies, and there are quite a number of them, as you probably have seen. And like Bitcoin, these are digital representations of value. And to one degree or another, they can be traded. They may function as a medium of exchange, unit of account, store of value. With Bitcoin, I'm told, you can pay for your 12-inch Italian BMT sandwich at a few, Subway stores. You can pay your Dish Network bill. You can buy a Walmart gift card, not from Walmart. And you can buy a new couch on Overstock.com. And you can buy and sell these cryptocurrencies for speculation or for whatever reason or purpose you want through a number of unregulated online trading platforms that are calling themselves, as you may have seen, exchanges. But blockchain technology has really generated a huge amount of interest beyond Bitcoin and virtual currencies. And for us, it is what promise it holds for a new technological paradigm in capital markets, and which for purposes of my remarks today means more than just markets where participants trade financial assets like stocks and bonds. Our focus is capital market structures and processes, capital formation, and corporate governance. As a prime example now, not long ago, Overstock.com became the first publicly traded company to issue digital securities in an SEC-registered public offering. Now, these securities exist only on a blockchain. It's pieces of code. Purchases, ownership, transfers of those securities are recorded only on the blockchain. And they trade separately from conventional Overstock securities and outside any centralized payment, clearing, or settlement process. Regular Overstock securities trade on NASDAQ. These securities, digital, trade completely separately apart from that. And not just Overstock, but we talk about today a major market infrastructure project that's underway in Australia. The Australian Stock Exchange is right now fully engaged in the process of replacing its entire support system for transaction clearing, settlement, asset registration, and other post-trade services with a blockchain-based system. And if all goes well, early next year, the Australian exchange will become the world's first blockchain technology-enabled stock exchange, and the changes will be extraordinary. Now, for capital markets, blockchain is truly what we could call a disruptive technology that, in addition to transforming how markets work, will fundamentally challenge our current legal and regulatory approach to them. Let's just say that it creates a great deal of legal and regulatory uncertainty. But before we dive deeper into that, let's pause to take a moment to get our arms, to the extent we can, around some blockchain basics. I saw this quote the other day. The commentator said, I think it makes it easy, right? The commentator said, blockchain is a big electronic system on top of which you can build applications. That's my kind of definition. but I think we need to know a little more about it. Blockchain technology, in our discussion today, is actually shorthand for blockchain and distributed ledger technology. The two are very closely related. A blockchain is actually a type of distributed ledger. And a distributed ledger is really simply a database that exists on multiple computers in a network. Those computers you will hear referred to as nodes in blockchain lingo, existing on those computers at the same time. A blockchain is a digital ledger of transactions or events among those multiple parties. And in a blockchain, the ledger constantly grows as new sets of data are added in packages called blocks. Whenever a new block is added, the blockchain updates and is then propagated to the entire network. Each node, all right, participant computer on that network is in sync, receiving the same database, the same ledger. The blocks are secured, and they are linked to prior blocks with a cryptographic algorithm called a hash. So they actually do form a chain, if you could represent them and see them. And blocks from all previous transactions are locked in place. Information added by a new block is verified. And security features involving this sophisticated cryptography prevent anyone from tampering with it or with any past information. And the result is a secure, chronological record that tracks every detail of every transaction within the chain from the very beginning, the so-called Genesis block. Data can't be edited or deleted by participants after it is written to the ledger. And this is the meaning of an immutable record in blockchain lingo. Now, keep in mind that all this happens in a completely decentralized manner, in a peer-to-peer network of unaffiliated parties. The blockchain isn't controlled by anybody. There are no intermediaries. All participants receive a copy of the ledger. It's distributed to all nodes, if you will. Old blocks are preserved forever, and new blocks are added to the ledger in real time, synchronized across the network for purposes of access by all participants. Now, the information, I say theoretically, can't be manipulated. It will always have to be qualified by that theoretical, because there may be ways, but right now the thought is it can't be manipulated, and so that blockchain is by very definition independent, transparent, and secure. Now, there are fully transparent public blockchains, networks like Bitcoin. The Bitcoin blockchain is accessible by all of us, anybody who wants to participate. And the data on the blockchain, the Bitcoin blockchain, is available to everyone in an encrypted form, and you have to jump through a couple of hoops, and there are addresses and keys that you may have read about. But nevertheless, it's a public, transparent blockchain. Now, there are also permissioned blockchain networks where there are only parties that are granted access to them. Now, there can be a single organization, perhaps, that has a permissioned blockchain, or a consortium of organizations. The permission network will allow anyone to join once you establish identity and what your role will be in the blockchain. And by role, we mean what each participant is allowed to access and contribute to the network. Whether it's public or permission, the blockchain records records the complete history of all transactions in the network that take place peer-to-peer among participants. All right, no doubt you're asking, how do I get one of these and who creates them? Well, putting it simply, they are built. They already exist and are available to run your particular blockchain applications or programs. Perhaps you've heard of the Ethereum blockchain, for example. But blockchains for capital markets applications that we're talking about are mostly permissioned blockchains. The Australian Stock Exchange, for example, has partnered with a US-based blockchain developer, Digital Asset Holdings, to develop the blockchain network being implemented there. Overstock.com created its own private blockchain for issuing and trading its securities. IBM, no surprise, has now entered the space with its IBM blockchain platform, which is designed to support blockchain developers in creating their own enterprise-ready blockchain networks. There are lots of freelance blockchain developers who are in demand now, and consortiums that you will see, like the Linux Foundation, are bringing together technology and capital markets firms to develop some standards for blockchain technology in capital markets. Now, talking about blockchain basics, especially in capital market applications, there's one more important thing to grasp. So far, we've taken this very brief look at blockchain technology. The focus has been on this distributed ledger, all right? The creation of this ledger, distributing it throughout all participants in the network, everyone having it updated as it happens. A blockchain is that form of distributed ledger, and it records and stores information, but we have to go a step further. The blockchain has to do something other than just immutably record information on a block. There's something more that makes the blockchain special, and I guess we could say in a way that gives it life across the broad spectrum of applications that we're particularly interested in. Have you heard about smart contracts? If you haven't, you will. Smart contract is a buzzword, okay, or a term. It's become closely associated with blockchain technology. It's kind of misleading because what it really refers to is not really smart nor really a contract. You know, we lawyers likely conceptualize a smart contract in terms of legal rights and obligations, something raising distinctly legal issues. But we lawyers aren't computer programmers, at least many of us aren't. And the programmer's concept of a smart contract is something that's programmed onto the blockchain simply to act as an electronic agent. All right, it's a computer code that runs on a blockchain, and it's programmed to collect certain data, to watch and collect, and upon the occurrence of certain events, it takes actions automatically. No human interaction, no intermediary. Now, think about a vending machine. You put in a $1.50, and the machine dispenses your bottle of water. Now, there's actually a contract built into that system that says if you put in the correct amount of money, the machine will deliver the product, right? There's nothing between you and the machine. The machine is programmed to determine that you have deposited the right amount of money, you put in the money, and then you have to, of course, have that leap of faith that the machine is stocked with stuff, okay, and that it's mechanically working, and that is a leap of faith. But the analogy still holds. And but if it's all working, the machine dispenses. There's your bottle of water. It executes automatically. All right. Now I'll plead guilty to oversimplification here, but the analogy pretty well illustrates a smart contract. there are rights and obligations, right, between you and the owner of the machine that have been programmed much like a smart contract. The smart contract that sits on a blockchain automatically does something when some conditions are met. It knows what those conditions are. It's been programmed. The conditions are met. It automatically executes, and it automatically enforces itself by, for example, transferring an asset or causing, think about this, causing a payment to be made. You know, getting out of the vending machine, but it's the same concept when certain conditions are met. So what's the big deal with blockchain technology and smart contracts for capital markets, all right? Now, let's revisit Overstock.com for just a moment. If you're familiar at all with Overstock, you know it's a public company, okay? It's been a public company for a while, and it has conventional common stock. It went public some years back, and its conventional common stock trades, as I mentioned earlier, in the NASDAQ stock market. Now, in 2015, Overstock filed a registration statement with the SEC under the Securities Act of 1933 for an offering of $500 million worth of various forms of securities, additional securities, all right? Its common stock is already trading. Well, this is an additional offering of some $500 million in various, there was common stock, there were preferred stocks, debt securities, and these were offered as digital securities. Maybe we should call them crypto securities. I mean, we call everything else crypto this or crypto that. So we call these crypto securities, but the thing is, these securities were offered directly to the public on Overstock's own proprietary blockchain. Now, the company explained to prospective investors in its prospectus for the offering that digital securities are, and I'll quote, uncertificated, registered securities, the ownership and transfer of which are recorded on a proprietary ledger, unquote. Now, again, that ledger, a distributed ledger, a blockchain, records ownership and transfers of those shares in a completely decentralized digital environment. Overstock explained in its prospectus that digital securities are designed to enable trades to settle immediately or nearly immediately, unlike traditional securities. And because they exist only on a blockchain, these digital securities are held directly. They're not held in a depository system or nominee system. They're simply held directly. In the nominee system or normal capital market system, you might think you've heard of a depository trust company or DTC, very commonly associated with ownership and transfer of securities. It's a process, all right? Well, blockchain for Overstock securities does not involve any of that. Held directly, recorded directly for you on the blockchain. Now, Overstock put it very right when it said, digital securities are novel, that quote puts it just like it is, are novel and untested and do not follow accepted conventions. Well, no kidding. And I should also point out that secondary trading in these securities was set up to take place on the blockchain as well. This is an SEC-regulated digital platform that operates entirely separate and apart from the NASDAQ stock market, where conventional Overstock shares trade. And the value of these digital securities is not pegged in any way to the market value of the other securities that trade on NASDAQ. Value happens, all right, but it's not pegged. Now, to say the least, Overstock did break new ground. This was the first, and it demonstrated the potential to transform the way securities are issued and traded. It was a challenge for the SEC staff, first time around, really unconventional. And the SEC staff, of course, is wedded to an 85-year-old regulatory structure that governs public offerings, and it goes without saying, was never designed to accommodate blockchain technology or crypto securities. So the staff of the SEC worked very closely and cooperatively. It wasn't as if it was immediately pushback, okay? There was no immediate pushback by the staff. They said, let's see what we can do. So they worked with Overstock, and there was an extended registration process, a great deal of back and forth, before the SEC gave the green light, in other words, granted effectiveness to the registration statement for these digital securities in 2016. Now, the novelty of digital securities and what Overstock did in the actual public offering of digital securities on a blockchain outside of any of the traditional processes that we know or think about of transfer of ownership of these securities. But there's something more fundamental, even more fundamentally important in the blockchain picture. Consider this for a minute. Securities markets in the United States are linked to a centralized national system for what we call clearance and settlement of transactions, which is regulated under a legal structure that is established in the Securities Exchange Act of 1934. Key provisions right there you see, and why we have this system of regulation of the system itself, and more importantly, the entities that are part of the system. Now, simply stated, clearance and settlement together comprise the processes by which, think about it, ownership of securities is transferred and counterparties' obligations like payments and deliveries are discharged. The thing is, today, and as it has been, clearance and settlement is largely a manual, multi-step process from pre-trade to trade, the actual transaction, post-trade, the payment, delivery of these things, to custody, DTC, other custodial organizations that actually hold and nominee names, for example, those shares that you purchased, and what we call security servicing, things that happen post-trade. It's this multi-step process, and by multi-step, that means there are intermediaries along the way, different entities, different organizations performing these multi-steps. Now, the national system for clearance and settlement that we have depends on these several regulated entities to perform the critical functions. We have clearing agencies. We have depositories, like DTC. We have transfer agents. They perform the critical intermediary functions. And we call these entities, participants along the way, we call them trusted intermediaries. All right? Things go through them. Ownership changes and transfers through them. Transactions occur, payments are made, deliveries are made. Through them, they are trusted to perform these functions. We don't do it directly, all right? They're trusted intermediaries. That's the language of blockchain technology, and the key is that our system doesn't function without them. The national system for securities clearance and settlement in the United States is really the epitome of a centralized, trust-based intermediary system. Clearing agencies, the most prominent one being the National Securities Clearing Corporation, act as central counterparties. And it's so critical because that is the central counterparty, NSCC, is the buyer to every seller and the seller to every buyer as these transactions take place. It's an essential part of our market structure. And then you layer into this process the depositories, again, primarily DTC, the Depository Trust Company, and the transfer agents who then complete the process for the records of the company. Now, in our current clearance and settlement system, each entity involved in what we call this trade life cycle, you know, the pre-trade to the final completion, it's a cycle. We call it the trade life cycle. And these entities must have to maintain their own records. And just very basically, when you think about that, there are inherent delays. And really, there's a significant susceptibility to errors being made. You know, there's a reason that when you leave today and decide to buy 100 shares of Tesla common stock, that'll take place electronically in the blink of an eye, right? But it's nevertheless going to take 2 business days from today to clear and to be settled. And as you know, that was only recently reduced to 2 business days from 3. Not long ago, we operated under the 3 business days. And altogether, as I say, we call this the trade life cycle, and it's an eternity. How can you buy in the blink of an eye? But it takes 2 more business days to settle, to actually complete a transaction. There's a cost for this. And just as importantly, there's a settlement risk exposure. Things happen, or can happen, during that kind of twilight zone period where all of this is taking place. Each step of the way, it takes time for clearing and settlement to happen. Now, you know, it's not just a risk to you and each participant in the process. It's a systemic risk in our system. In the wake of the 2008-2009 financial crisis, of course, that led to the Dodd-Frank Wall Street Reform and Consumer Protection Act, which, among a lot of other things, created something called the Financial Stability Oversight Council, the FSOC, which is charged with the task of identifying what we call systemically important financial market utilities and financial institutions, based on a pretty straightforward determination that if one of them would fail, you know, this is the too big to fail concept in Dodd-Frank, if one of them would fail or there were a disruption to its functioning of, say, a financial market utility, like a clearing organization, these are financial market utilities, that would threaten the stability of the U.S. financial system. Now, as I say, the major U.S. clearing organizations, like National Securities Clearing Corporation, have been designated by the Financial Stability Oversight Council as systemically important financial market utilities, based on that determination. And the regulatory structure established for these intermediaries that, you know, again, going back to the baseline provisions of the 1934, the Exchange Act, established to regulate, it really is pervasive and has become more pervasive even as we have moved on and carried out some of the mandates of the Dodd-Frank Act and creating new markets and, you know, new types of securities and new types of systems that are mandated and requirements that are mandated for clearance and settlement of exotic things that were said to be at the heart of the world financial crisis back at that time. But here's the thing, a blockchain-based system running smart contracts, all right, keep that point that the blockchain is a distributed ledger, okay, lots of records, immutable and all that, but it has to make something happen, okay? A blockchain system running smart contracts can eliminate centralized, and here we go, trust-based systems and all these inefficient and expensive steps in the trade life cycle. You know, ideally, transactions could be cleared and settle. All right? And clearance is the transfer of the ownership, right? Settlement is the payment. The process, it involves these different intermediaries, could be cleared and settled on a blockchain in near real time, directly between the parties. I mean, that block, which incorporates all the other blocks, and boom, it can happen virtually, instantaneously. It has been said, the people that study this, that settlement risk exposure. Now again, we're talking about time equals risk here, all right? The time it takes is one thing, but it also, the functioning of the intermediary is another thing. I mean, there can be errors. Lots of things, as I say, can happen during that period of time. It's said that this settlement risk exposure could be reduced by 99% through blockchain technology, where there is, remember, no centralized structure. There are no central counterparties. The whole idea of central counterparty, buyer to every seller, seller to every buyer, all that in-between stuff doesn't exist. It all happens directly. The record of the transaction is at once permanent, immutable, as we say. What is happening with implementation of blockchain technology in Australia is going to have a major impact. Obviously, in the trade life cycle there. Their system is much like, for clearance and settlement, that the infrastructure, the market infrastructure, is much like our own, and other places as well. But if they successfully, and they have, I mean, it's on the way, and it's expected that, after the first of the year, it can be up and running. The impact on the trade life cycle, just the way I've described it, as the potential, could be reality. And it's going to reverberate, okay, if it works, right, through other markets. This long-standing Australian clearance and settlement system, it's operated and it's been regulated very much like our own. It's going to be substantially eliminated. Now, the objective of that blockchain-based system to replace it is that, look, there's going to be a record, immediately, a record of every tradable security through the entirely decentralized blockchain, every transaction, every transfer, and every payment. Right there, instantly. Now, those in the know say that what is happening there right now in Australia is the largest implementation of blockchain technology in the world. Now, our neighbor to the north in Canada is at work on this as well. Project Jasper is a collaborative effort between the Bank of Canada, the TMX Group, which is the parent of the Toronto Stock Exchange, and others. And they're testing the feasibility. And again, I'm testing the feasibility. Australia has gone much further than that, but they're testing the feasibility of instantaneous clearing and settlement of securities transaction using an integrated securities and payment settlement platform, based on distributed ledger technology and blockchain, and using, of course, digital securities. So again, there's another aspect to this. This whole process may certainly work better with actual digital securities as opposed to, how should we say, conventional or the real thing, right? Now, also, the European Securities and Markets Authority, that's ESMA, is also examining right now, they're doing studies on how distributed ledger technology can interact with the existing regulatory framework in Europe. There's nothing there up and running yet. But, again, closer to home, the Federal Reserve Board staff not long ago published an extensive analysis of the potential benefits of distributed ledger technology throughout the U.S. financial markets, and specifically with regard to reducing transfer information times and trade execution, from execution to settlement, and eliminating duplication of record keeping, if nothing else, and costly reconciliations that take place through this multi-step process. But again, extensive study, but no action plans at this point, however. Now, NASDAQ has actually developed blockchain and deployed it, blockchain technology in the operation of something called the NASDAQ private market. Now, this is a platform. This is not the NASDAQ stock market as such, all right? This is a platform created by NASDAQ, operated by NASDAQ, the private NASDAQ private market, for trading private company securities. This NASDAQ system, which is called LINQ, L-I-N-Q, is being used to complete and record private securities transactions for several client companies. The first one, by the way, it was called Chain.com, first company to use the NASDAQ link to issue shares to private investors, private placements, and manage post-trade events and processes and subsequent permitted transfers. You know, the issues that face investors holding restricted securities in private companies is they have much less opportunity for liquidity, and there needs to be an outlet for liquidity, need to be liquidity events, that sort of thing. And it's a challenge. NASDAQ Link is designed for those client companies that now sponsor liquidity opportunities to have a market, very restricted, but have a market nevertheless based on blockchain technology that they're issued, they're traded, permitted only trading, but nevertheless it's all done on the NASDAQ link, which is a blockchain system. Now, other companies are now, besides, I mentioned Chain.com, are successfully using Link to carry out and complete private securities transactions to and with and among their investors. And the thing is, blockchain technology enables the secure issuance and transfer of these securities, these shares. Now, NASDAQ is also leading the development of a blockchain-based platform for resolution of margin calls, which is an element involved in all markets, stock markets, through direct collateral transfers on a blockchain. And this means it will enable transfers of collateral to meet margin calls, for example, to be accomplished in near real time with absolutely no intermediary involved. And again, where time equals risk, the impact is large. Now, it's disruptive technology, for sure. The multi-step settlement and depository functions at the heart of our existing system could simply become unnecessary. And a recent report, some British researchers concluded that an efficient blockchain-based system presents the possibility of complete disintermediation of markets, eliminating participants currently performing all of these functions. Blockchain can provide a tamper-proof, think about it, a tamper-proof audit trail of the transfer of securities, or any asset for that matter. In capital markets, we're thinking of financial assets and securities. But blockchain technology can deal with the transfer of any asset. And there are many, many applications, real estate, all different kinds of things, without having to rely on any trusted third-party intermediary. And these intermediaries are the focus of our current regulatory structure. We have to say that in markets that could no longer require the presence of regulated intermediary entities, what form of regulation would be necessary or appropriate? At best, we can say, well, that's uncertain at the moment. But what we can say is that at least as to clearance and settlement, blockchain technology can deliver a number of regulatory benefits, reducing trade errors, operational risks, counterparty risks. Why? Because you're introducing into the system true straight-through processing and instantaneous execution and settlement of transactions. And all of this is fully transparent and accessible in real time by the SEC, for example. The SEC could become a privileged participant on the blockchain, part of that network. Immediate access for regulatory purposes. You know, blockchain technology can also be, and starting to show, that it can be disruptive in corporate governance. Consider this situation. 2013, Dole Food Company did a merger, consummated a merger with, that company was taken private, okay, by its major shareholder. But it had to do that by way of a merger, and there was a shareholder price the shareholders received of $13.50 a share. Okay, not unusual. A class action was filed on behalf of shareholders in Delaware Chancery Court that said, well, this isn't really fair. That price that we're getting is too low. And the case eventually settled in 2015. And settlement called for an agreed additional payment to the shareholders of another $2.74 plus interest. Now, the settlement said, well, look, the settlement proceeds will be distributed to the shareholders, the additional proceeds, distributed to shareholders through a traditional class action claim process. Now, in the class, there were, of all shareholders, there were 36,793,758 shares in class. So far, so good. Problem was, at the conclusion of the claims process, the claimants had submitted facially valid claims for 49,164,415 shares. So somehow the shareholders owned 33.5% more Dole shares than there were Dole shares. How so? Well, the fault lay with Depository Trust Company, DTC, which kept the centralized ledger of Dole shares. But it was unable to determine the actual ownership of shares at a critical point in time, namely the date on which the going private merger closed. All right, there was some 32 million shares that had traded in the 2 days prior to that date. And in our then existing T+3 system, the trade date plus 3 business days for clearing and settlement, these trades had not cleared prior to or at the merger date. All right? And DTC, centralized ledger, simply showed that whoever owned Dole shares as of the 3rd day preceding the merger owned them at the date of the merger, the date it closed. Obviously not so. Transactions that had occurred in the 3 days before the merger closed but had not cleared were just not reflected on the centralized ledger. It was a real snafu. Multiple owners submitted claims for shares involved in trades that had not cleared. Whoever showed up on DTC's ledgers as holding shares could submit a claim, but so could the beneficial owners who had acquired the shares and therefore owned them at the time of closing, but were not yet recorded by DTC. 2 different claimants could submit facially valid claims for the same shares, and they did. Well, there was a reconciliation eventually achieved at a great cost. But it led Vice Chancellor Lassiter, who administered this whole thing in Chancery Court, to say that, you know, distributed ledger technology is the potential technological solution for this kind of situation. Why? Because maintaining multiple current copies of a comprehensive stock ownership ledger. The systemic problem that you have here could be prevented, he said, by using a distributed ledger where every broker-dealer, for example, could instantaneously record trades that would be visible to all participants. Ownership rights would be clear in real time for every share. Well, now Delaware has since taken a step legislatively to permit corporations to implement blockchain technology to maintain shareholder records. The Delaware Corporation Law was amended last year to provide that the required corporate stock ledger, which is a matter of law that has to be maintained, can be, quote, maintained on one or more electronic networks or databases, specifically including one or more distributed electronic networks or databases. And importantly, those records can be used to prepare the list of stockholders that's required by law, to record all the required information, and to record all the transfers as they occur. The Delaware amendments also specifically said the use or participation in one or more electronic networks or databases, including one or more distributed electronic networks or databases, are permitted as electronic communications, in addition to the record keeping, were permitted under law. Wyoming followed suit not too long after that. We're talking very recent situations now. And amended its corporation law to permit shareholder records to be administered and maintained on a distributed or other electronic network or database. Tennessee came along. Recently enacted legislation to recognize the validity of blockchain technology, to provide that blockchain records are, for legal purposes, electronic records, and any person using blockchain technology to secure information has the same ownership rights to the information as he or she had before securing the information. Now, here in Ohio, maybe you saw very recently, it's only been a matter of some weeks, if that, the General Assembly redefined electronic record expressly to include a record or contract that is secured through blockchain technology. And it redefined electronic signature expressly to include a signature secured through blockchain technology. Now, that's a baby step, all right, but it's using the right terminology and it has the right idea. And more actually is on the horizon in Ohio, it seems. At least very, very recently, the Speaker of the House called for creation of a working group. This is still in the process of being formed, to advise and assist the legislature on developing specific blockchain-related legislation in Ohio. Well, oops, got that. Beyond eliminating situations like Dole Foods, shareholder voting generally presents an opportunity for employing blockchain technology. How? In order to secure accurate proxy voting. Now, there are a number of flaws that are common in proxy voting. Incomplete distribution of proxies, inexact shareholder lists. Dole Food is the standout example of that flaw. And they're the more mundane but meaningful problems, inexact records, problematic vote tabulations. These are all attributable to this kind of cumbersome and really unsecured proxy voting process. It can be addressed by blockchain technology. Here again, NASDAQ has stepped in to successfully test a platform it developed using blockchain technology to run proxy voting on one of the NASDAQ-owned stock exchanges, the Tallinn Stock Exchange. Okay, yes, it's in Estonia, but it's like the sandbox, all right? And it's working for shareholder voting, and it is going to be licensed right now outside the United States. It allows online voting during shareholder meetings, transferring of voting rights to a proxy. All voting data is saved to an immutable distributed ledger, real-time access to voting results, no intermediaries in the process. Thinking back to something Vice Chancellor Lassiter said in Delaware, in a later speech he made, he called blockchain technology the plunger that would clean up proxy plumbing. NASDAQ's working on that. And again, we're seeing some states starting to set the stage for implementing things like that by these very basic steps that I've already mentioned. There's more, however, to consider about blockchain technology as a disruptor in capital markets. And this has led lately to some regulatory angst, all right? Blockchain technology opened the door to tokenization, all right, which for us means the creation and public offering of digital blockchain-enabled tokens. Now, these offerings are imprecisely called initial coin offerings, or ICOs. You see that all the time. They really should be ITOs, okay? Coins is really something different. But that's beside the point. A token is a digital asset Nothing more than some computer code bought with virtual currency like Bitcoin or Ether. And it's assigned then to a purchaser's address on a blockchain. No physical tokens, only a piece of code. Digital assets entitle holders to certain rights, all right? Normally to a venture, rights regarding a venture that underlies the ICO, like the right to share in profits of a planned project or enterprise, rights to use certain, maybe even rights simply to use certain services offered by the issuer. And there may even be some voting rights associated with these. These digital assets, these tokens, also may trade on online platforms. Some of them now are being called exchanges, where they're tradable for what? For virtual currencies, or frankly, the real currency too. So tokens that represent an economic right to share in future profits from a funded project now, call them equity or investment tokens, have been taken on directly by securities regulators. The value of these tokens is initially set by the issuer based on what it thinks the venture's worth at its current stage. Later on, value is determined through trading of these things. Token purchasers, as I say, can monetize their investments, reselling them on these web-based platforms that would be, or expected to be established to support trading. These equity or investment-related tokens, or ICOs, have drawn the attention of securities regulators. Well, a simple question. Wait a minute, are you offering and selling securities in the form of investment contracts? That's one of the, it's one of the terms in the laundry list of things that are defined to be securities under both the Securities Act of 1933 and Exchange Act of 1934. And if so, you have to comply again with our 85-year-old structure for the offer and sale of securities, which, unless there's some exemption available, must comply with the registration requirements, prospectus delivery requirements, and that whole thing. So, the question is, well, does this old law fit new facts? Or an SEC commissioner recently said, can old law go digital? And the answer apparently is, in this setting, the answer is yes, because the SEC has come down, and state regulators, by the way, have come down hard on these offerings. It really started just in 2017. The SEC issued a report of an investigation regarding, it was not an enforcement action as such, it chose not to because it had been shut down, but it looked at a situation in which a German company had offered and sold tokens. They called them, you'll see this referred to as the DAO, D-A-O, these tokens, which refers to something called decentralized autonomous organization. That's a geeky term that describes something that's not really terribly important to us. But anyway, it was a for-profit company, and it had the objective of holding these assets that were being raised through the sale of these tokens to fund, hopefully, profit-making projects. And the holders of the token stood to share in the anticipated earnings of the project as a return on their investment. It was offered that way. They were promoted to induce an expectation that you'll be able to resell these things in various ways, including a secondary market, and they will increase in value. Well, the SEC said, we don't have to think too hard because we can go way back if we want to the original 1946 case. If you want to look at it, a Supreme Court case way back then that set the stage for determining what is a security in the form of an investment contract, and they did. An investment of money in a common enterprise, expectation of profits to be derived from managerial efforts of others. Okay. So as I say, the SEC did not bring, the Dow shut down, all right? It raised millions of dollars, but all of that was returned. And that report was issued to put the, the token or the ICO industry on notice that there is a problem here. And just last summer, Bill Hinman, who's the director of the SEC Division of Corporate Finance, really underscored the point. He said that almost invariably, where a digital asset represents a set of rights that gives the holder a financial interest in an enterprise, it's going to be a security. SEC Chairman Jay Clayton said pretty much the same thing. And as I said, when the SEC contacted the Dow, they shut it down. And the industry is on notice now. Now, I should say, keep in mind, there are some digital tokens that are offered and sold in ICOs that could be structured so as not to be a security. If you can structure so it can currently be used to purchase some goods or services from the issuer, it's not deemed to be a security. These are called access or utility tokens. But you make that regulatory determination on a case-by-case basis. And really, the most recent attempt to invoke saying these are really utility tokens was rejected by the SEC because what they were really doing in order to get to the stage where they would be utility tokens is they were funding the development of the app that would lead to that with the proceeds of the initial coin offering. And by the way, they were also sold with representations that they would increase in value and that there will be a secondary market to trade these things. Well, at the baseline, ICOs, as I say, that amount to securities trigger violations of the Securities Act of 1933. And they're going on. You read about them. They're not going away. ICOs are essentially, they have ignored these requirements. And the regulatory focus has not only been on the more technical side of this, you're offering and selling securities in violation of registration and those requirements, but there's fraud. These things tend to involve, or at least allegedly involve, a good deal of fraud. Consider for one very recent example I kind of like. The issuer claimed, it's all black and white, The issuer claimed that a regulatory agency, the BEC, that is the Blockchain Exchange Commission, regulates blockchain digital asset space to protect digital assets investors. And the BEC had approved that ICO offering. They put a logo on it that looked like the SEC's logo, and they actually used an address that was an address of the SEC. Well, look, obviously, there's no BEC. And just for some color, seriously, the BEC that represented by this issuer was originally formed by that issuer in 2015, and I got to say it, as Fart Life, LLC. Right? The thing is, they raised millions of dollars. And that's what's going on. The attraction, they are raising these funds. And maybe you saw, I'm not sure if it's still up, but there was for a time, the SEC had put up a mock ICO offering on its website, designed to attract attention and go through all the stuff in a very realistic-looking way. When you get to the point of clicking, I want to, purchase whatever, well, then it takes you to a whole explanation of what's wrong with all of that situation. Now, state securities regulators, as I said, they're focused on fraud actively. State securities regulators always focus on fraud. And there are several enforcement actions brought by state regulators. Also, these online platforms that are being created for trading digital assets, facially at least, they invite regulation as, believe it, national securities exchanges by definition. Then you've probably seen digital wallets. You have to have a wallet in order to acquire the virtual currency, in order to make the investments, whether it's Bitcoin or Ether, in these things. These face potential regulation, both under the Exchange Act regulatory structure, as clearing agencies, transfer agents, and there are other laws, state laws that apply. There's a controversial one right now in New York that created a licensing requirement for people that, among other things, are transmitting virtual currencies. A lot of pushback on that, but this is what the states are doing. Thinking for a short term now, since our time is running short, about the regulatory uncertainty that comes with consideration of broader capital markets, particularly clearance and settlement, and this the fact that we are built around a entirely centralized system. If you just think about that system for clearance and settlement for a moment, can blockchain technology and smart contracts substantially eliminate the need? I mean, there are questions about this. That's why we aren't there yet. We'll see maybe what happens in Australia. But could they have substantially, there's a reason we have central counterparties. And they perform an important function. Blockchain seriously eliminate the need for that counterparty function of clearinghouses. Clearinghouses ensure the completion of transactions and mitigation of risk, a failure of a counterparty to perform or fulfill its obligation. Central counterparty clearing system has benefits beyond the pure function of clearing. It mitigates these risks, mandates a form of, our legal structure mandates a form of self-governance applicable to these intermediary agencies and imposes ultimate responsibility on these intermediaries subject to SEC oversight. Somehow, these arrangements, these systems for some kind of clear, transparent governance are still going to have to be in place, you would think. But it's not clear. It's not clear how, if at all, disintermediation is going to preserve the benefits that we acknowledge exist with the central counterparty structure that we have. There'll be answers, and we'll keep an eye on Australia for some of those answers, perhaps. There's a lot of positive impact if you want to go the other way. Well, by imposing creating a blockchain-based structure for regulation, for example, consider the positive impact that the SEC would have direct access to the shared ledger. And that shared ledger can make for automatic regulatory reporting, real time, support continuous auditing of financial statements. Where's the SEC right now? Jay Clayton, SEC chairman, and other top SEC officials have said, relatively recently, that the SEC remains open to the potential benefits and efficiencies that blockchain can bring to capital markets. And just a few days ago, literally last week, the SEC launched something called its Strategic Hub for Innovation in Financial Technology, FinHub for short. And FinHub is intended to serve as a resource for the public to engage with the SEC on fintech issues, specifically including distributed ledger technology and digital assets. But I'll tell you, beyond the enforcement initiatives that are being directed to ICOs in the wake of the DAO situation, as I discussed earlier, and the fraud-infested crypto schemes generally, the SEC has really devoted broader market regulatory attention just to one aspect of blockchain technology, and that actually is on virtual currencies, cryptocurrency markets, and creating. Cryptocurrencies are not securities, okay? But they are playing a role in offerings and creation of platforms and programs that are investments related to, say, Bitcoin. There have been a number of these things. And these things can be deemed to be securities, again, based on the fundamental legal analysis, and the SEC is focused on those. And you may have seen there's a big flap. Recently, the Winklevoss brothers wanted to create exchange-traded funds based on virtual currencies. The SEC would govern that and has declined to permit the creation right now of those ETFs, exchange-traded funds, because of fears of manipulation, market manipulation, based on the underlying virtual currency market. I suppose, to finish up, maybe, since we like tech things, let's focus perhaps on reg tech. I didn't coin that term, but it means looking at blockchain technology to facilitate and improve on our existing regulatory structure and procedures. Look, blockchain offers tools, we've seen that, to promote more efficient, reliable compliance within the existing capital markets regulatory environment. I said at the beginning today, blockchain may hold promise for a new technological paradigm, but perhaps we should be looking at what we can do far better with blockchain technologies, with what we have in our existing markets before thinking about these transformational changes or paradigm shifts, because paradigm shifts don't come easy. SEC Commissioner Hester Peirce, who we actually had at the law school last week on another program, but a week or so before that was at the University of Michigan Law School, and she said the essentials of a well-functioning market do not change because technology changes. Look, her message is that while a market regulatory structure can and should be adaptive, and perhaps even evolutionary, the purposes and objectives of regulation don't change. Technology matters, but markets must be better, and regulatory compliance must be accelerated because of the technology. So no predictions on exactly where we're headed. Let's keep an eye on our Aussie friends and pay attention to these ever-increasing voices from across the capital market spectrum here and abroad saying there really is a bright future. All this has to sort out to understand the potential, what it can do. But being disruptive, we have to understand to what extent. And again, this whole idea of reg tech may be the best approach right now. And a number of people are saying, take it one step at a time. Well, in closing, look, there are real challenges for lawyers in everything that I've discussed. SEC Chairman Clayton said that, look, lawyers are the gatekeepers in the context of ICOs and blockchain-related capital formation undertakings. We've got responsibilities to focus our attention on investor protection objectives of the securities laws, where there is a call for our judgment and our expertise in dealing with these things. There's so many challenges going forward beyond also our discussion of capital markets today. Just think about it. We're necessarily going to at some time have to determine to the extent to which traditional legal concepts and functions can realistically be automated. Smart contracts? What does that really mean for us as lawyers? I could go on about that and the potential disruptive impact in the practice of law. Maybe we can do that another time. But for now, we have come to the end of our time. It's been a great pleasure to be with you. Thank you so much. Hey. Sure.
Why did Overstock decide to go that route? Was it just an experiment?
Yeah. Yeah.